And we talk about interest in land. Interest in land can take the three the three forms. It's either an estate, a servitude, or an encumbrance. It may be freehold or leasehold. And a freehold land confers rights for an indefinite duration, and you can inherit, and it can also be transmitted. You take the example of ancestral land. It was before you were born, a generation came into existence, that generation passed on, another generation inherited, we are currently there, and the future generations will also inherit it. And freehold estates include a free simple. A free simple is the largest freehold that a person can have on land at common law, and it confers the largest quantum of rights: unrestricted right to use, misuse, and dispose. And in the event of death, the rights are transmitted to the person entitled to inherit the estate, and there are no conditions attached to the inheritance, and it can be disposed by deed or will, wholly, in part, unconditionally, or conditionally. And we'll refer again to that ancestral land. You find that it may be divided amongst the sons. The sons again will divide amongst the children. It continues in that way. And there is no, you dispose it by use of a will, and you can dispose it fully, or you say leave 2 acres for plantation. Leave 2 acres and make sure you plant trees. These 2 acres can never be tilled. These 2 acres can never be built upon. And a fee simple is either by grant or inheritance, as we have said, or where the government has leases. Upon the expiry of the leases, think about these white settlement schemes, whereby upon the expiry, the land automatically reverts back to the state. And now the state can decide whether to apportion it or increase the lease term. We talk of a fee tail, and it confers a life interest on the holder, and it descends only to specified persons. And this is generally created by inheritance. What you buy and want to pass on to your future generations, or what you buy and you want to gift someone, and they hold it so that they're able to transfer it in future. And for freehold, we talk about absolute proprietorship, and it is upon registration. Registration will terminate all customary rights exercisable on that land. This is where you've bought and you take the documents, a transfer is done, you take your ID, the old title deed, take it back to the lands, and you're given your new title deed in your name. And for estates, we also have leaseholds, and we consider them tenancy. And a lease is a transaction which creates the relationship of a landlord and tenant. And the formal document is what is called a lease. Leasehold is the quantum of rights which a lease grants on the lease. It's a secondary interest in land derived from a primary interest. And it confers upon the leasee exclusive possession of another land. And when we say it is a secondary interest, if the property you have and it's a leasehold and it says 99 years from the time you bought it, let's say you bought it 3 years ago and you are granted 99 years. If you sell it after 5 years, you can only sell the 99 minus 5. You cannot grant any more than what you have. And the characteristics of that is that there's exclusive possession. A tenancy will confer upon the grantee the right to hold to the exclusion of others. It means there will be no interference with how you carry on the business in your land. And we also talk about a defined premises. It's not arbitrary. It's not ambiguous. It is determined on a specific piece of land that is well known, that can be identified, that you can actually pinpoint and say, this is my piece of land. And the documentation proves that it is that one. And it is for a certain period. We've said 99 years. It could be 199. And that, the reason it is not rounded off to 200, that last year, when it remains some few months, you're supposed to take it back and renew the leasehold. And the types include a fixed tenancy. This is a fixed duration. We are doing this for 10 years. That is fixed. And that's the commencement and termination must be specified. So we will put it in writing that starting the first day of November 2024, and it will run up to October, 30th October 2029, both days inclusive. So that is specified. It's not left up until either party decides to terminate. There's also a periodic tenancy, and it's indefinitely from a period to period. We put it open that once 1 year is done, we can continue, we can proceed to the next year. And it may be express or implied. So there's also a tenancy at will, which will terminate in the event of death. This tenancy at will, it is for as long as you and I have this property, you and I are agreeing to the terms and conditions. So where none of us or one of us is not present, then that tenancy terminates. There's also a tenancy at sufferance, where it's created by law. And there's occupation without the landlord's consent. So the law forces this relationship, but where you pay rent, then it becomes periodic. And the problem with tenancy at sufferance is that the tenant may be elected at any time without notice. We have the obligations of the parties. In a leasehold, we have the lessor and we also have the landlord and the tenant. And the duty of the landlord is to ensure quiet enjoyment. Do not disturb your tenant. You do not interfere with their right to enjoy what they have paid for. And this means you don't put restrictions. If they had intimated they need parking, you don't go harassing them and telling them, no, don't park on this grass, do it there. You don't also impose your beliefs. If you are Christian and you go to church and now you want to knock on your tenants and tell them, no, we have to all go to church, or anything that may be construed as disturbing their right to enjoyment, that one is not allowed. And as the landlord also, the premises must be fit. for purposes. If it is a house, it must have proper sanitation, it must have proper ventilation. If it's a business premise, again, proper disposal of waste. The reason to which it is being let, it must be fit for that. There's also the duty to repair, such that if the doors are falling apart, the landlord must ensure the premises are kept in a manner likely and to ensure enjoyment of rights. If there was a door at any given time, then he cannot come and remove the door and say today it will be like this. No, they need to ensure there's the right to enjoy and the right to repair. So now that we've seen the duties of the landlord, what about the tenant? And one is to pay the rent. And it is paid irrespective of occupation. What this means is, if you say that from January 2024, I am occupying your premises, George, then I decide I will live in, I will move in after 3 months. I will move in March. If I am your tenant, whether or not I am occupying, but we had agreed from January. So I am supposed to pay, I am obligated to pay for the entire period, whether or not I have occupied the said place. The tenant is also not allowed to transfer, to sublet, or part with possession. You cannot give again what you do not have. If the property is not yours, you can't rent it out to someone else. You don't have the capacity to enter into an agreement with a third party, because yourself, you're already in a contract with the owner, with the landlord. So you cannot again purport, because of the rights you have accumulated or acquired as a tenant, to look for another tenant to be under you. You're also allowed to permit the landlord to view the premises, and this will go hand in hand with the repairs, ensuring that there's the right to enjoyment. And there's also a duty not to erect fixtures. That is, you're not allowed to, let's say you've rented a standalone house and you assume you can put up a business for selling ABCD. Then you want to put up that shed. You're not allowed to do that. And these rights and duties to the parties. Remember, a tenancy agreement may be written. So these are general ones, but where there's a tenancy agreement, whatever you sign, whatever you bind yourself to, is what you will rely on in the day-to-day. If you had agreed rent is due on 5th, then you are bound by that. Rent is due on 5th. If you had agreed you can only let the landlord in on Saturdays during working hours, and the landlord agreed to that and gave you his house, then that is also what will happen. So while what we are saying is the general, the nitty-gritties, the finer details will come on that contract you have agreed with the landlord or the lessor or that owner of the property. So leases do terminate, and one is by notice. And this notice must be clear that within a month, I want you out of my premises. So I'm not giving you room to negotiate. I'm not giving you room to tell me we can add rent. No. Simply within a month, kindly move out, hand over the keys to the gate man, remove all your property. There's also the element of surrender, and it must be in a prescribed form. So the tenant surrenders to the landlord and the landlord agrees. And a license differs from a lease in that a license is a permission given by the occupier of the land without creating an interest in the land that allows the licensee to do some act which would otherwise be a trespass. And a license does not confer the right to exclusive possession of the land. It's a mere permission by a party to another to enter the licensor's land, and it does not require any writing or registration, and more importantly, it is not transferable. License, you can imagine where you're given a license to extract something from the land. It's different from tenancy because you're only there for that specific role. You don't get to do anything else apart from what has been agreed on. So an interest in land, we have talked about estate, and now we will talk about servitudes. And servitudes are rights conferring a power on another's land for the benefit of the right holder or his estate. And they include easements, profit prendre, and restrictive covenants. Easements are rights attached to a parcel of land which allows the proprietor to use the land in another, to restrict its use to a particular extent. And an easement may be positive or negative. So it's positive if it authorizes the use of another's land in a particular way. Negative, think of restriction. It restricts you from acting in a particular manner. And easements that they must be dominant. And rather, there must be a dominant and a servient tenement when it comes to easement. So two aspects of that need to be in existence. And they must be occupied by different persons. This is because an owner cannot have easement over his land. And easements are created either through express grant. The rights to the grantee are prescribed in a manner, also through statute granted by an act of parliament. Lastly, will be upon prescription, where the Limitation of Actions Act says that 20 years of continuous use of another's land grants an easement to the user. The law may have been updated, but that element of continuous, without giving the owners any breathing space. And these use, in these, think of squatters, that when they come and you make no effort to evict them from your property, the first year passes, the second year passes, children grow, families widen, then you are not allowed to, after a period of time, to say that no, now you move. So there's that Limitation of Actions Act. It prescribes for how long can someone stay unwelcome in your land before they claim ownership of that similar land. And easements are terminated through lapse of time. We also terminate them due to the occurrence of an event. And this occurrence is a breach of terms, where something has happened that the terms have been breached. We also talk of the registered a judicial discharge, where the court is empowered on application by an interested party in order to terminate this easement. If there's a justification, a proper justification, a reasonable cause as to it to happen. Profit a prendre is the right to take something off another's land. That you have a neighbor, you have seen that he has started digging up gold deposits, and you want to go to his property and take those gold deposits and sell them and gain money. And if you get this profit, then it should be profit in common with the person whose land you went and took something from. And it may be created or acquired through express grant, prescription by law, and we terminate is the profit apprended by release or abandonment. You just let it go. You say it's not worth it and you move on swiftly. Encumbrances constitute burdens on the property, and they're generally temporary. These are either mortgages or charges. And a mortgage is a conveyance of land or that is used as security for payment of a debt or the discharge of some other obligation for which it's given. And one of the characteristics is that the title to the mortgage, now you can no longer transact using your title, because up until you're able to pay off the amount given, then that mortgage company owns either that house or that piece of land in which you want to build. And we have a simple mortgage transaction without delivering possession of the mortgage property, and the borrower binds himself to pay. And where there is non-repayment, the mortgagee shall have the right to sell the property and restore himself to the position he was in if you are not introduced to each other. There's also a mortgage by conditional sale, where the borrower sells mortgage property to the mortgagee on condition that even in the event of default, the sale becomes absolute, or in the event of payment, the sale becomes void. This is where we are saying you owe microfinance, a certain microfinance, 60 million shillings, and you've not been able to pay. The fact that you are unable to pay, then the property will be sold and that sale becomes absolute. There's nothing you can do when you have agreed to have that mortgage by conditional sale. You advanced money, you buy the house, but you deliver the title to the person issuing you with the mortgage. That in the event that you default, then that sale becomes absolute. But should you pay, the payment makes that sale void. You as the mortgagor or the charger, you're supposed to pay the principal interest, pay all taxes on that land, to keep the premises in repair, to ensure that in the joint names of all the parties, and to honor the terms, how you agreed to having a mortgage. Then you honor the terms and make sure that you pay.